Good morning, everyone. It is nice to see you all come together today. My name is Gaston Alonso. I am the director of the Ethel R. Wolff Institute for the Humanities at Brooklyn College. On Monday, we came together in this room as a community to welcome Melissa Murray, our Karen Robert L. Hess Scholar-in Residence. And today, we come together for Professor Murray's Hess Memorial Lecture titled Funhouse, Footnote 4, How the Roberts Court is Remaking Constitutional Order. And with that, it is my honor to introduce Brooklyn College's Provost, April Bedford.
Good morning. Unfortunately, President Anderson had a late scheduled meeting with Brooklyn Borough President Antonio Reynoso right now, so she's unable to be here, but she asked me to say a few remarks on her behalf. So on behalf of Brooklyn College and President Anderson, I would like to welcome all of you to the Hess Memorial Lecture by our renowned 2025 Hess Scholar-in Residence, Melissa Murray. We take great pride in the fact that Brooklyn College is known for its rich offerings in the humanities, and we're proud of the nearly half-century legacy of the Ethel R. Wolff Institute for the Humanities and its dedication to carrying out Brooklyn College's commitment to history, philosophy, literature, music, art, sociology, anthropology, and all the disciplines that explore what make us human and help us understand the world around us, and this is needed more than ever at this moment in our country. So thank you everyone at the Wolff Institute for the Humanities, including Director Gaston Alonso and Kiana Benjamin, as well as the other academic departments, staff, students, and faculty who have lent their time and their tremendous talents to this incredible series. I've seen some of the behind-the-scenes details that have gone into planning, organizing, and actually making this amazing week happen, and I can only imagine the countless hours that our dedicated staff, faculty, and students have invested in bringing this experience to all of us. Many, many thanks. Personally, I had the great good fortune of being invited by Gaston to attend lunch yesterday with Professor Melissa Murray and a number of the panelists here for Hess Week. And my key takeaway from that event was that Melissa has an ardent group of fans. A number of the guests mentioned how they would do anything for Melissa, and we have all heard that at various sessions all week. The events and your thought-provoking comments have so far exceeded our expectations. I can't thank you enough, Melissa, for sharing your time and insights with all of us this week at Brooklyn College. Professor Alonso mentioned on the first day of Hess Week, which many are now calling Melissa Week this year, that the events he and his partners have so meticulously and lovingly planned are a gift to the college, and they indeed are. I'm so delighted that our students have the opportunity to be in the room with Professor Murray and her esteemed colleagues, both the guests to Brooklyn College and our own remarkable faculty. It's truly been a joy to watch our students and faculty learn, question, and wrestle with ideas alongside each other at all of the panels, and I know today's lecture will be a continuation of that. Melissa, your time with us at Brooklyn College and your invitation to include so many amazing scholars and thinkers in this week's events have also been a gift to us all. And I know that we will continue to open and unpack and explore that gift long after this spectacular week is over. Thank you all for being here. Now I will welcome back Professor Gaston Alonso, Director of the Ethel R. Wolff Institute for the Humanities.
And thank you to Provost Bedford. Without your participation and your support, none of this would have been possible. So thank you. Now, this morning, I also want to thank the members of the Hess Planning Committee who have spent the last 8 months dreaming this incredible week up, and then making it happen, especially during this week. We have worked so hard together. If you're in the room, please stand up so we can acknowledge you. Their names and the names of officers and individuals on this campus who have helped us do all of this are listed in the program. Please take time to read their names and honor them. I also have to thank the school paper, the student paper, the BC Vanguard. for the awesome story that they published in yesterday's edition. Check it out. Which gave me a lot of insight into Professor Mary and how the journey that has brought her here. Now, I also have to thank, on behalf of the hundreds and hundreds who've joined us in the Tanger and have been joining us on the live stream. I have to thank, on behalf of them, the scholars, the legal experts, the community members who have been participating in our public events. At yesterday afternoon's event, the last event of yesterday, one of the students thanked the panelists. He said, "Thank you for not forgetting working class students." And I cry every time I say thank you, so it's going to happen again. Thank you for not forgetting working class students. Right? And I want to thank Professor Mary and all of the experts who've come, including some who are in the room with us today. I want to thank them for coming to Brooklyn College. Thank you for sharing with us, sharing your expertise, your passion, your wisdom, your vision for a more just world. And I have to thank our students. And some of you I have seen at every session. I take note. Some of you have been to every session so far. And I want to thank you for showing up. I want to thank you for demanding an education, as you always do. I want to thank you for reading Professor Mary's work, engaging with it, showing up, asking the tough questions, disagreeing, agreeing, right? Being willing to learn and to teach, to do so respectfully. I've been so proud of you. I said on the first day that we were going to give the world a vision of higher education, of public higher education at its best, and I think we have done that. So thank you. I also have to thank those who made this all possible. The Robert L. Hess family and the Robert R. Hess Memorial Fund for so generously funding decades of Hess Scholars and Hess Weeks, allowing us to honor the memory of former college president Robert L. Hess by furthering the mission of the humanities at Brooklyn College. And then I have to give a huge thanks, and I'll probably cry again, to someone who has become an inspiration, and that's Melissa Mary, our current scholar. Thank you for inspiring this week. Thank you for helping us design the programming for the week. Thank you for coming to our college. Thank you for your intellectual engagement with us. Thank you for being in community, like truly being in community with us, teaching us at a personal and at a collective level how to understand the power of the law in ways that if we will it, can point us towards a more vibrant and a more just world. Thank you. And now, I will stop my thinking and crying. And it is my honor to introduce my colleague from the Department of Political Science, Distinguished Professor Corey Robin.
Thank you all. Thank you all for coming. So, when I was in high school in the early, can everybody hear me okay? So when I was in high school in the early 1980s, one of my favorite things to do was to watch a television show on PBS called The Constitution, That Delicate Balance. I'm actually just realized I've made an inadvertent confession about the state of my social life when I was 17, but please, let's pass by that. The show was hosted by Fred Friendly, who was a legendary newsman who had worked with Edward R. Murrow to help bring down Senator Joseph McCarthy in 1954. You might know of Friendly as George Clooney, who played Friendly, who, truth be told, was not the most attractive man, but he played him in this movie, Good Night and Good Luck, and talk about male privilege to be played by George Clooney in one's life. That's pretty nice. But in 1984, Friendly was concerned with a different set of threats to the Constitution. Across 13 episodes, he gathered a diverse group of experts to ask and answer the following questions. Is the way we elect a president a disaster waiting to happen? Can the president make a decision of national importance without consulting Congress? How many aliens can we absorb? That was 1984. I didn't realize this at the time, but each of those issues, which seemed at the time to be entirely hypothetical, was in fact a political time bomb just waiting to go off. And now they have. In recent years, it's become fashionable to bemoan the state of our public conversation. Where is our Fred Friendly, hosting an intense yet informed, academic yet accessible discussion on the airways of the most vital issues of the day? Where are the dialogues that Friendly staged between ideological antagonists like the New York Times columnist Anthony Lewis and the ferocious right-wing judge Robert Bork, between Pat Schroeder, the fiercest and funniest feminist from Colorado, and Orrin Hatch, the Utah Republican of the Christian right? I think the answer to that question is right in front of me and right next to me. Every week, Melissa Murray, our Hess Scholar-in Residence, takes to the airwaves, whether on Strict Scrutiny or MSNBC or NPR, to do for our time what Fred Friendly did for his. But Murray brings something more to the table. An extraordinarily distinguished scholar, Murray doesn't need to put questions to other experts, although she does. Instead, she brings her own constitutional analysis, honed in the nation's most prestigious law reviews and other venues, to the conversation. In today's world, there are a number of academics who are eager to present their research to the public. They're called public-facing scholars. But what they mean by that is to take some extraordinarily complicated bit of scholarship, kind of dumb it down to the lowest common denominator, add a few bad jokes and pop cultural references, and then send it out. I've been reading and watching and listening to Professor Murray for years. And here's the thing, she never does that. Every comment on television or a podcast sounds like a perfectly constructed, heavily footnoted paragraph from one of her law review articles. And every one of those perfectly constructed, heavily footnoted paragraphs in one of her law review articles sounds as alert and alive as her performances on television. I used to think of that as a skill. I've come to think of it as an ethos, a reflection of how a person, a scholar, thinks about their world. For Murray, there's only one audience. It doesn't matter if it's in law school, on television, in the New York Times, or Brooklyn College. Murray speaks to us, all of us, as intelligent readers, students, and citizens. That requires a deep and firm commitment to egalitarianism and a deep and enduring faith in democracy. Professor Murray has become America's teacher. We are so fortunate to have Professor Murray, America's teacher, as this year's Robert L. Hess Memorial Lecturer. Please welcome her to Brooklyn College.
Well, that was quite a buildup. I'm not sure if I'm going to be able to live up to that, but let me first start by saying thank you. Thank you to Professor Alonso and the staff of the Wolf Institute and all of the members of the Hess Week Planning Committee and all of the students at Brooklyn Law School for this extraordinary welcome this week. It has been my privilege and honor to be in community with you all. When Professor Alonso mentioned that student yesterday who thanked us for not forgetting the working class students, I just want to say I can't forget the working class students because I was a working class student. I was, as I said on Tuesday, born not far from here in Methodist Hospital in Park Slope, and I spent the first 5 years of my life living in an apartment building on Ocean Avenue where my Jamaican parents lived in a community of other Jamaican immigrants. I worked my way through college. I worked my way through law school. I just paid off my law school loans about 2 years ago. It can be done. Thank you. It was an achievement. So I remember what it was like to worry about how to pay rent, how to buy books. And and how to sort of climb the ladder in a country ostensibly the land of opportunity. And so I see the fight that you are in. I applaud your fortitude as you go about this. There's nothing more important than education, and I see how deeply engaged you are in the project of your own educations this week, and I salute you, because there truly is nothing more important, nothing more vital to the health of this democracy than people like you working to be a part of it in a real and sustained way. So thank you. The title of this talk is Funhouse Footnote 4, which may prompt some of you to ask, what is she talking about? Footnote 4 refers to the fourth footnote in the Supreme Court's 1938 decision in United States versus Caroline Products. This is the most famous footnote in all of constitutional law. Caroline Products was a challenge to the Filled Milk Act, which was a federal law that prohibited the shipment in interstate commerce of milk that had been adulterated with other products like coconut oil or condensed milk. Congress enacted the Filled Milk Act after intensive lobbying from the dairy industry, which was keen to constrain the market for cheaper adulterated milk products. After successfully lobbying for years for state laws that prohibited the sale of adulterated milk products in a number of states, Big Dairy set its sights on a federal law that would further choke the supply of adulterated milk products throughout the country. And Congress, despite the nation's depression-induced economic woes, complied, enacting the Filled Milk Act with bipartisan support. The Caroline Products Company, however, was not going down without a fight. It was one of the largest manufacturers of adulterated dairy products, and it produced a popular product known as Milnot, or Milnut. This was a blend of milk that had been compounded with coconut milk for extra creaminess. Already reeling from the state-level laws that artificially constrained the market for filled milk products, the federal law prohibiting the shipment of Milnut in interstate commerce was likely to devastate Caroline Products. And so the company sued to challenge the Filled Milk Act, arguing that Congress lacked the authority to enact the law, and even if it did have the authority to enact the law violated the Fifth Amendment's Due Process Clause. Now, if Caroline Products had filed its lawsuit just a few years earlier, it likely would have been successful. In the early days of Franklin Roosevelt's administration, the court was well known for its skepticism of the New Deal Congress and Roosevelt's efforts to regulate the American economy. But unfortunately for Caroline Products, its lawsuit was filed in 1937, which, coincidentally, was the year that the famed switch in time occurred. Now, the switch in time is well known to students of constitutional law, but let me unpack it a little bit. Roosevelt was absolutely incensed by the court's recalcitrance with regard to the New Deal. He was eager to advance the New Deal programs, and he was eager, especially, to put the recalcitrant court back in line. And so FDR floated a plan to pack the court with younger justices who were more amenable to the New Deal's regulatory proclivities. Now, the court-packing plan never really got off the ground. It was very unlikely that Roosevelt would have been able to marshal the required votes in Congress to add more seats to the court. But in any event, the threat of court packing was potent enough to convince one justice, Owen Roberts, to switch his vote in a pivotal case, National Labor Relations Board versus Jones and Laughlin Steel Company. This pivotal case involved unions and collective bargaining. Now, in the brief period between 1937, when Jones and Laughlin was decided and the switch of time occurred, and when the court took up the Caroline Products suit, the court's jurisprudence also took a turn, a switch, if you will. The court now took a more expansive approach to Congress's authority to enact legislation under the Commerce Clause, dramatically increasing the number of activities that could be considered within or to affect interstate commerce. Now, much of the New Deal's regulatory programs would pass constitutional muster and be sustained. But it also altered the jurisprudence in the area of substantive due process, the doctrine dealing with rights that were not specifically enumerated in the Constitution. And those changes meant that many New Deal programs that the court previously would have struck down as unconstitutional were now likely to be found constitutional. And so it was with the Filled Milk Act. Relying on its recent expansive understanding of the commerce power, the court determined that the Filled Milk Act was well within Congress's authority to regulate interstate commerce, subject only to the restrictions of the Fifth Amendment. And with regard to the Fifth Amendment, the court saw no problems. Congress, it concluded, had a rational basis to assume that the law was needed to advance public health goals. The case was a staggering defeat for Caroline Products, and the decision most likely would have been consigned to the backwaters of the U.S. reports were it not for its marginalia. Caroline Products nominally might have been a case about filled milk products and the government's authority to regulate national markets, but at bottom, it was also an existential question about the role of an unelected, unaccountable court in a constitutional democracy where the people's representatives, Congress, the president, state legislatures, and state executives routinely took action that these unelected, unaccountable courts routinely reviewed and sometimes struck down. The bottom line question in Caroline Products was whether judicial review was consistent with democracy. Should unelected, unaccountable judges be in a position to invalidate the actions undertaken on behalf of the people by their elected representatives? It was the central question that undergirded the recent fight between FDR and the court. The court's decision in Caroline Products upholding the Filled Milk Act reflected the current view of the court, where the court noted that Congress had a rational basis for legislating and that the court should not second-guess the wisdom of those legislative judgments when they were proper. After all, if the people objected to the work of the elected branches, they could simply go to the ballot box and use the political process to, quote, vote the bums out. But did that mean that the political process and the ballot box was the only check on the political branches? Was there no role for the courts to play in limiting the work of those who were elected? Although the majority decision in Caroline Products deferred to Congress and upheld the Filled Milk Act, Justice Harlan Fiske Stone, who wrote the majority opinion in Caroline Products, was not prepared to say that there was no role for the court to play in policing the elected branches going forward. Although Stone conceded that in most cases, the court owed the elected branches deference in the reasonable exercise of their constitutional authority, in the fourth footnote of the majority opinion, he briefly sketched those limited circumstances where the courts should not simply defer to the elected branches, circumstances where the courts were obliged to review the actions of the elected branches with more exacting scrutiny. So what were those circumstances that required more searching judicial review? Stone identified three. Circumstances where government actions imposed upon the exercise of fundamental rights, including those rights explicitly detailed in the Bill of Rights. More searching judicial review was warranted in those cases because those rights were so important that they could not be left to the vicissitudes of majoritarian politics. Relatedly, more searching judicial scrutiny was warranted in circumstances where the government's actions impaired the political process. Because in order for a democracy to function, for the people's will to be expressed faithfully and accurately, the people had to be able to represent their preferences and their objections to their representatives at the ballot box. Accordingly, courts were obliged to intercede when the government had taken steps to render the political process less responsive to the people. Finally, Stone recognized that regardless of whether the political process was functioning properly, there would still be groups that Stone termed discrete and insular minorities, who, because of their minority status, would not be able to rely on majoritarian processes to protect their interests. In circumstances where the elected branches took actions that discriminated against those discrete and insular minorities, the courts were obliged to intercede to protect and vindicate minority interests. Essentially, in this footnote, Justice Stone sketched a vision for the role of the courts in a constitutional democracy. As he explained, in most circumstances, the courts should defer to the work of the people's representatives, even if they disagreed with those actions as a matter of policy. And the Filled Milk Act was a perfect example. Although members of the court privately expressed reservations about the act's effectiveness or even what it was supposed to do, They acknowledged that it was well within Congress's authority to enact the law, and as such, they deferred to Congress in upholding it. But not every government action required such deference. When the government's actions involved fundamental rights, rights too important to put to a vote, or impaired the political process so that it was no longer a means for the people to express their will, or where it discriminated against discrete and insular minorities who could not vindicate their interests in majoritarian politics, the courts could not simply defer to the elected branches. In those circumstances, the courts were obliged to step up and step in and review the government's actions with more exacting scrutiny. Now, to be sure, Footnote 4 is more well-known than the decision in which it is nested. I doubt many lawyers could wax lyrical about the facts and the resolution of a challenge to the Filled Milk Act. But almost all lawyers, and certainly most law students, remember Footnote 4 of Caroline Products, because it is the settlement on which our modern understanding of the court as a defender of rights and of minority rights in particular was built. Consider what followed after the court's decision in 1954's Brown versus Board of Education. There, the court famously overruled Plessy versus Ferguson and declared separate but equal, and the Jim Crow regime that it underwrote, unconstitutional. In the immediate aftermath of Brown, the South was in open revolt. Not only did Southerners drag their feet at the prospect of integration, they openly challenged the court's authority to mandate it. There were calls to impeach Chief Justice Earl Warren, and there were also academic challenges to judicial review that framed the court's actions in Brown as counter-majoritarian. As these academic critics mused, how could a court of 9 unelected lawyers overrule the wishes of a majority of Southerners, as reflected in the policies that had been enacted by their elected representatives? As the logic went, the Brown court's overruling of Plessy was not just wrong, it was anti-democratic. Similar concerns attended the court's decisions around voting rights. In upholding the Voting Rights Act, the federal legislation passed in 1965, which imposed upon the states traditional authority to administer elections in the manner of their choosing, the court opened itself up to claims of counter-majoritarianism and federal overreach. Not only did the VRA ignore the wishes of the majority of Southerners, it made the states subordinate to the federal government in the administration of state elections, an area of traditional state concern. Controversy over the court's actions in Brown and the voting rights cases roiled for decades. But then one scholar stepped forward to answer the question of whether the court's actions in these civil rights cases had been proper, and more importantly, whether they had been consistent with democratic ideals. In his 1981 book, Democracy and Distrust, A Theory of Judicial Review, constitutional law scholar John Hart Ely sought to defend the Warren Court and its decisions from claims of counter-majoritarianism and judicial activism. Building on Footnote 4 of Caroline Products, which identified a more searching brand of judicial scrutiny for circumstances involving fundamental rights, the political process, and discrimination against discrete and insular minorities, Ely argued that the court's role in a democracy was to bolster and to safeguard the infrastructure of democracy and to facilitate political participation of those who were routinely excluded. On this account, judicial review was legitimate, absolutely legitimate, if it was deployed to facilitate the political process and protect the interests of discrete and insular minorities. This is how Ely defended Brown and its overruling of Plessy. It was a necessary action intended to facilitate the political and social participation of a long-subordinated group. Likewise, the Warren Court's voting rights decisions were also patently legitimate because they helped to make the political process more representative by including in the electorate those who had formerly been excluded. Ely's analysis was eminently persuasive. Although Brown and the voting rights decisions were criticized when they were announced, over time, they have come to be viewed as legitimate, even canonical. So much so that even conservatives concede that Brown and the voting rights decisions that followed were rightly decided. And indeed, they have marshaled both decisions in their own work. This is all to say that Footnote 4 was and has been the foundation for the court's modern civil rights settlement. It is the bedrock on which the court's role as a defender and protector of rights, and minority rights in particular, is rooted. But if footnote 4 is the origin story of the modern court's status as a defender of rights, what explains the Roberts Court? Much ink has been spilled on the Roberts Court's approach to stare decisis and precedent. This is hardly surprising. In just the last 5 years, the court has overruled extant precedents on issues that range from abortion to jury convictions to property rights and public unions. It has also substantially narrowed and limited existing precedents relating to affirmative action and voting rights, curbing the reach of earlier decisions in ways that disrupt and distort the jurisprudential landscape. Given this track record, it is hardly surprising that some constitutional law scholars now argue that the Roberts Court no longer reflects this vision of the judicial role that Ely outlined in Democracy and in Distrust. In an article entitled The Anti-Caroline Court, Harvard law professor Nick Stephanopoulos argued that the Roberts Court has disavowed the core tenets of Ely's vision of the role of the court in a constitutional democracy. Now, Professor Stephanopoulos is surely correct in observing that the Roberts Court does not wield the judicial power in the manner of the Warren Court or even earlier courts. But as I argue, it is a mistake to label the Roberts Court an anti-Caroline court. Because the Roberts Court, in my view, is in fact following the footnote 4 approach. The Roberts Court is exercising judicial review and the authority to reconsider and even overrule past decisions in order to vindicate fundamental rights, to safeguard the political process, and to protect discrete and insular minorities. The difference, though, lies principally in how the Roberts Court conceives of fundamental rights, how it conceives of assaults on the political process and its integrity, and how it conceives of the identity of those minorities most in need of the court's protection. Put differently, the Roberts Court is exercising its judicial power with footnote 4 firmly in mind. But it is not the footnote 4 that we have come to know. Rather, the Roberts Court is pursuing a distorted vision of footnote 4, a funhouse footnote 4, if you will. So what do I mean by this? How many of you have gone to a carnival with a funhouse where there is a mirror that distorts your reflection? Yes. I have too. Sometimes the mirror renders you larger. My favorite is when the mirror renders you skinnier. Either way, the mirror distorts your image, often rendering an inversion of the real image, recognizable in its contours, but ultimately substantively different. In the jurisprudential context, the court's distorted vision of footnote 4 operates in much the same way the Warren Court's pursuit of footnote 4 did, which is to say it is recognizable in its contours, but it is substantively different. Because the court understands itself to be protecting fundamental rights and preserving the political process and vindicating the rights of discrete and insular minorities, but it is different in that the court's understanding of the fundamental rights that should be protected and how the political process should be perfected and who are the discrete and insular minorities that need protection is fundamentally different. It is wholly different from what we have known. Consider, for example, the Roberts Court's treatment of fundamental rights. As we have discussed at length this week, in 2022, the Roberts Court overruled Roe v. Wade and Planned Parenthood v. Casey, the twin pillars of the court's abortion jurisprudence that outlined a fundamental right to abortion. And it did so on the view that the Constitution does not explicitly articulate a right to abortion, and such a right cannot be inferred from the history and traditions of this country. In doing so, the court actually elided a very obvious history that might have informed the question of whether the 14th Amendment implicitly underwrote a right to terminate a pregnancy. Those who drafted the 14th Amendment explicitly acknowledged that certain basic freedoms, the freedom to marry, the freedom of bodily autonomy, the freedom of family integrity, were fundamental human rights that had been denied to those who were enslaved. If liberty was the antithesis of slavery, then the exercise of those rights were what made liberty liberty. It is what characterized and distinguished the free citizen from the enslaved. And indeed, during the congressional debates on the 14th Amendment, Senator John Sherman underscored the importance of securing as fundamental rights these rights of family and bodily integrity for newly freed African Americans. After all, the trappings of freedom and citizenship, he noted, would always be elusive, quote, where the wife is the property of the husband's master and may be used at his will, and where children are bred like stock for sale. On this view, Sherman surmised, quote, no act of ours can fitly enforce their freedom that does not contemplate for them the security of home. The framers of the 14th Amendment understood these rights to family privacy and bodily autonomy as fundamental. But these narratives were curiously absent from Justice Alito's majority opinion in Dobbs. The Roberts Court approach to abortion rights contrasts sharply, though, with its approach to rights under the Second Amendment. As the Roberts Court has made clear in cases like District of Columbia versus Heller, the mere fact that the right to keep and bear arms is explicit in the text of the Second Amendment makes clear its status as a fundamental right. But it's not just that the court regards the Second Amendment as textually conferring a fundamental right. It is that the court went out of its way to mine the history of enslavement to expand the scope and substance of the Second Amendment beyond what is textually committed. The day before the court issued its blockbuster ruling in Dobbs, it issued another high-profile decision in Bruin versus New York State Rifle and Pistol Association, a challenge to New York State's concealed carry firearm permitting regime. In invalidating the New York regulatory scheme, Justice Clarence Thomas, who authored the 6-3 majority decision in Bruin, went beyond simply confirming that the Second Amendment conferred an individual right to keep and bear arms for home security. It justified an expansive understanding of the Second Amendment that went well beyond the home, and it did so by plumbing the history of postbellum racial violence against newly freed African Americans. As Justice Thomas explained, during Reconstruction and Redemption, Southern states relied on restrictive gun laws and other official actions to thwart newly freed Black men who sought to exercise their Second Amendment rights. The divergent approaches to 19th century history in Dobbs and Bruin are noteworthy. In Bruin, Justice Thomas mined Reconstruction history to underscore the view that not only were Second Amendment rights fundamental, key attributes of citizenship, but he argued that they also should be broadly construed, not just as a matter of constitutional interpretation, but as a matter of racial justice. By contrast, in Dobbs, the court focused stubbornly on the Constitution's text and the absence of a textual commitment to the abortion right, and instead looked to 19th century criminal laws to make the case that there was no constitutional right to choose an abortion, studiously avoiding a widely available history that made clear that the 14th Amendment's grant of liberty contemplated protections for bodily autonomy and family integrity. In so doing, the court made clear the rights that it views as fundamental, the ones that are textually committed, and that those textual rights are well within the bounds of the court to expand, offering a maximalist vision of what the Constitution has committed. In a similar way, the Roberts Court has also breathed life into a distorted vision of Footnote 4's understanding of the court's role as a protector of the political process. Under the Warren Court, the court's charge to protect and perfect the political process meant that the court routinely intervened to ensure the principle of one person, one vote. In 1962's Baker versus Carr, the court effected a sea change in politics by ruling that redistricting challenges aimed at securing equal representation could be heard in federal court. Just 2 years earlier in Reynolds versus Sims, the Warren Court articulated the one person, one vote doctrine, concluding that state legislative districts must contain roughly the same number of voters. These changes, coupled with the court's support of the Voting Rights Act of 1965, completely reshaped the electoral landscape. In the wake of these interventions, voter participation by racial minorities steadily increased, and indeed, by 2012, the year of a presidential election in which the United States elected for the second time a Black man to the highest office in the land, minority participation in politics had reached an all-time high. Today, though, the Roberts Court invokes the Warren Court's ethos of facilitating voter participation and ensuring the representation of diverse voices, but with an entirely different impact. In the name of protecting corporate speech, the Roberts Court, in its 2010 decision in Citizens United, has defanged campaign finance restrictions and allowed corporate wealth to exercise outsized influence on the electoral process. Its 2019 decision in Russo versus Common Cause effectively blessed partisan gerrymandering, allowing state legislatures to draw legislative districting maps in ways that consolidate partisan control and make representative government less responsive to the will of the people. And perhaps most profoundly, in a series of decisions from 2013's Shelby County versus Holder to 2021's Brnovich versus DNC, the Roberts Court has steadily hobbled the Voting Rights Act, allowing states and localities to enact suppressive voting laws and limiting avenues for individual voters to challenge these impositions on the franchise. The incremental hobbling of the VRA returns power to the states and their legislatures at precisely the moment that the court, through its gerrymandering decisions, have made state legislatures less representative and less responsive to the people's will. Put simply, the Roberts Court has turned the political process logic of Caroline Product's Footnote 4 on its ear, making the political process less amenable to broad participation, amplifying the voices of certain wealthy constituents, while making it easier for states to limit the impact of underserved minority voices. And perhaps the most significant way that the Roberts Court has inverted and distorted the Caroline Product settlement is in its treatment of discrete and insular minorities. Footnote 4 made clear that courts were obliged to intervene and use the judicial power to protect discrete and insular minorities who, because of their political powerlessness, were unable to protect themselves in majoritarian politics. On this logic, the courts were duty-bound to intercede on behalf of these minorities, invalidating laws that were enacted even where they were enacted with majority support. Footnote 4's logic has for generations been associated with the liberal Warren Court and its support for civil rights. But as I argue, the Roberts Court is also acting on Footnote 4's logic. It is just that today, the court's understanding of who is among those discrete and insular minorities who require judicial protection is very different from that of the Warren Court. Consider the Roberts Court's treatment of affirmative action programs. Created in the 1950s to remedy the historic exclusion of racial minorities in government contracting, affirmative action programs soon migrated to other avenues of American life, notably higher education admissions. Over time, the court grew increasingly skeptical of the use of race in admissions decisions, but it nevertheless routinely upheld, by the slimmest of margins, the limited use of race in admissions protocols. That is until its 2023 decision in Students for Fair Admissions versus Harvard. There, the Roberts Court's 6-3 conservative supermajority overruled more than 4 decades worth of precedent, concluding that even the limited use of race to achieve classroom diversity was constitutionally suspect. In one fell swoop, the court dismantled affirmative action in higher education. But more profoundly, it made clear that it was less concerned with diversity and the inclusion of Black and brown students who historically had been excluded from elite higher education, and more concerned with the deserving white students whom it believed affirmative action harmed. In Biden versus Nebraska, also decided in 2023, the Roberts Court invalidated the Biden administration's student loan relief program. Biden versus Nebraska and its companion case, Department of Education versus Brown, nominally were about whether the federal government had the authority within the scope of a statute called the HEROES Act to enact the student loan program, waiving student loan obligations. Nevertheless, despite that narrow question, it was clear that some members of the court understood the real question in the student loan cases to be about whether this loan relief program was fundamentally unfair to those who had never pursued college. At oral argument in Department of Education versus Brown, Chief Justice John Roberts pressed this point in a hypothetical involving a small business entrepreneur who had never attended college and thus would never be eligible for student debt relief. Throughout the oral argument, the Chief Justice returned to this hypothetical person who he said, quote, started the lawn care service, a lawn care business, because he can't afford college. Justices Barrett and Alito, who joined the 6-3 majority to invalidate the student debt relief program, also referenced this imagined, quote, lawn care person who doesn't go to college and starts a lawn care business, pressing the, quote, fairness question. Because the court dismissed Department of Education versus Brown on jurisdictional grounds, it never had the opportunity to expressly plumb the question of whether student loan relief was inherently unfair to those who had bypassed higher education in favor of other occupational paths. Nevertheless, these exchanges at oral argument were telling. Read together, the student loan cases and the affirmative action case, Students for Fair Admissions versus Harvard, gestured toward the Roberts Court's interest in a kind of remedial justice. In SFFA, the court interpreted past precedents more narrowly than previous courts had done, and instead considered both implicitly and explicitly the degree to which the challenged race-conscious admissions policies and the precedents that underwrote them injured certain constituencies. But who were the constituencies with whom the majority was principally concerned? Although SFFA versus Harvard was brought on behalf of Asian American applicants who claimed to have been discriminated against in the admissions process, the majority spent very little time probing the nature of this Asian American discrimination. Indeed, the majority opinion mentioned Asian Americans only once, and then only glancingly. Instead of focusing on Asian Americans' discrete claims of discrimination, the majority gestured toward the broader unfairness of discrimination and the unfairness of the race-conscious admissions policies and the prospect of qualified applicants being denied admission in favor of those whom the court regarded as less qualified, Black and brown applicants. Put differently, the majority's discussion literally viewed this question in stark Black and white terms. And while the circumstances in the student loan cases had no obvious racial valence, one might argue that race and racialized grievance nonetheless shaped the court's approach to that case as well. Again, recall the Chief Justice's invocation of the imagined lawn care entrepreneur who had foregone college. The Chief Justice did not name or otherwise identify this imagined entrepreneur, but existing data can provide some demographic context for the hypothetical. Most small businesses in the United States are owned by white entrepreneurs. And data can also contextualize the group that the majority likely perceived as the beneficiaries of the Biden administration's student debt relief program. More than 50% of Black students take out student loans to finance higher education, and their monthly student loan payments are the highest across all demographic groups. Indeed, as amici detailed in briefs to the court, student debt relief would immediately and significantly impact racial minorities' ability to build wealth and capital, often for generations. Viewed in tandem, the student loan cases and the affirmative action case reveal the court's general antipathy for redistribution. But more importantly, these cases also make clear the court's desire to remedy the perceived injustices and injuries that redistribution may engender. Now, to be clear, redistributive policies necessarily advantages some over others, always. But tellingly, in Biden versus Nebraska and SFFA versus Harvard, the court's skepticism of redistribution aligns with its view that extant precedents and doctrines improperly facilitated this redistribution, and in so doing, imposed injuries on certain groups. And critically, these groups, these new discrete and insular minorities, were not the traditional racial minorities that the Warren Court once recognized. Instead, they are groups that historically we might understand as being part of the majority. This retooling of who is a discrete and insular minority deserving of the court's protection is also clearly visible in the Roberts Court's steady remaking of First Amendment doctrine. In recent years, the court has cast certain First Amendment litigants, namely religious conservatives, as besieged minorities. To be sure, the national climate has concretized for many religious conservatives the sense that they are an aggrieved minority group. Recent developments have resulted in the increasing secularization of civil society. Sexual activity has become untethered from marriage. Marriage rates and religiosity have declined. And the equality of racial and sexual minorities is now a public policy imperative in most jurisdictions. For many religious conservatives, these sweeping changes in gender roles and sexual mores throughout the 20th century have sparked a sense of cultural dislocation. And the court's own rulings, once recognizing a right to abortion and same-sex marriage, have exacerbated the view among many Christian conservatives that they are being, quote, left in the wake of a rising cultural tide. And the court has embraced this framing of Christian conservatives as among the discrete and insular minorities it is obliged to protect. The court's disposition of Kennedy versus Bremerton School District in 2022 is instructive. Coach Kennedy, an avowed Christian who happened to be an assistant football coach at a public high school, repeatedly engaged in a post-game practice of praying at midfield. The school district, concerned that a school official engaged in prayer at a school event on school property might give rise to an Establishment Clause lawsuit, demanded that Kennedy immediately stop the practice. Kennedy refused, prompting the school board to discipline him. He then filed suit, arguing that the school board's disciplinary action violated his First Amendment right to free exercise of religion. And a 6-3 majority of the Supreme Court agreed. As the majority explained, the dispute turned on whether Kennedy's prayers were private speech or government speech undertaken by a public official in the course of his official duties. The court concluded that the prayers were clearly the former, private speech. And although Kennedy was a school official, his prayers occurred when he was not engaged in official duties. As such, they were private speech, not government speech, rendering the school board's efforts to reprimand him improper and unconstitutional. The school board had objected that Bremerton was a diverse, multi-faith community and that there was rising concern that Kennedy's actions could be understood by some as the school district's endorsement of Christianity above other religions in violation of the Constitution's Establishment Clause. That is the First Amendment provision that prohibits the government from endorsing or appearing to endorse a particular faith. In articulating its concerns, the school board referred explicitly to an earlier case, Lemon versus Kurtzman, a 1973 court decision where the court articulated the longstanding test of state endorsement of religion. In Kennedy, however, the Roberts Court waved away these concerns, insisting that the school board had, quote, effectively created its own vice between the Establishment Clause on the one hand and the free speech and free exercise clauses on the other. It had placed itself in the middle and then chosen its preferred way out of its self-imposed trap. In rejecting out of hand the school district's Establishment Clause concerns and prioritizing Coach Kennedy's free speech and free exercise rights, the court repudiated the Lemon test as an abandoned doctrine. On this account, the praying coach is figured as a beleaguered victim, while the school board, with its concerns about the government endorsement of religion in a multi-faith community, is figured as an irrational antagonist scheming to use the Establishment Clause to thwart the praying coach in the exercise of his free exercise rights. The treatment of Coach Kennedy as the victim of state over-encroachment accords with the Robert Court's treatment of the litigants in two other First Amendment cases, Masterpiece Cake Shop versus Colorado Civil Rights Commission and 303 Creative versus Alanis, decided in 2018 and 2023, respectively. Both Jack Phillips and Lori Smith, the respective plaintiffs in Masterpiece Cake Shop and 303 Creative, maintained that their faith as Christian evangelicals required them to refuse services for same-sex weddings. In Masterpiece Cake Shop, the overarching clash between religious liberty and LGBTQ+ equality was never really resolved because the court concluded, in reviewing the underlying claim, that the Colorado Civil Rights Commission had violated Jack Phillips's right by exhibiting animus, that is, a hostility to religion or a religious viewpoint. In 303 Creative, decided 5 years later, the court did eventually get to the question, concluding that the First Amendment prevented the state from enforcing its public accommodations law to compel an individual to create pure speech and communicate ideas with which that individual disagreed. The Masterpiece Cake Shop Court's invocation of animus to protect Jack Phillips, a straight white Christian, inverts and confounds the traditional account of discrete and insular minorities. Historically, straight white Protestants have not been viewed as a politically unpopular group or as discrete and insular minorities in need of judicial protection. Indeed, we are more often likely to think of them as among the majority in society, among the most advantaged in society. Now, to be sure, demographics are shifting, and Christians are now a numerical minority, although just barely, in the United States. And this has fueled a narrative, one that the court appears to credit, that Christians are, like racial minorities, distinctly disadvantaged and aggrieved. On this view, because civil society has become increasingly secular and Christian evangelicals have perhaps become less numerous, they have been, quote, transformed into minorities who face discrimination and subordination in public life. In this way, public accommodations laws that were promulgated to limit discrimination are now refigured as vehicles of discrimination. And Jack and Lori Smith, individuals who refuse to provide services for same-sex weddings, are now transformed into victims of discrimination rather than purveyors of it. Casting Christian conservatives as minorities undermines the thrust of extant First Amendment doctrine, which emerged in the mid-20th century as a vehicle for promoting religious pluralism through protections for minority religious sects. As Justice Sandra Day O'Connor explained in 1991, quote, "The First Amendment was enacted precisely to protect the rights of those whose religious practices are not shared by the majority and may be viewed with hostility." While it is not clear whether the Roberts Court's revamped vision of religious freedom is intended to accommodate those sects that traditionally have been viewed as minority religious sects, that is, quote, unpopular or emerging religious groups like the Jehovah's Witnesses and the Amish, it is telling that in recent years, the court's free exercise clause has been deployed largely for the protection of Christian conservatives, as opposed to a wider cross-section of the faithful. And as cases like Masterpiece Cake Shop and 303 Creative make clear, the Roberts Court's muscular vision of the First Amendment threatens to effectively overrule, or at least undermine, extant precedents and legislation that prioritize civil rights ahead of religious liberties claims. In both cases, gay couples invoked Colorado's public accommodations laws. These are state civil rights laws that require small business owners like Jack Phillips and Lori Smith, who are doing business in the public sphere, to serve all comers, regardless of their religious beliefs. But on the Roberts Court's telling, these anti-discrimination laws are the problem, the real source of discrimination. As the court observed in 303 Creative, laws that impose anti-discrimination mandates may compel speech, forcing the business owner to adopt and endorse a message with which she disagrees. In their zeal to protect religion, decisions like 303 Creative and Masterpiece Cake Shop turn anti-discrimination law and civil rights into antagonists. So what unites all of these cases, from gun rights and affirmative action to voting rights and student debt relief and then religious freedom? When the record is arrayed before us, it becomes clear that across these different domains, the court's efforts benefit a particular group, those individuals who historically we have understood to be part of the majority. But now, that majority is now a discrete and insular minority whom the court feels obliged to intervene to protect. These are the individuals who have been injured by the court's earlier policies and by the public policy interventions that the court's earlier decisions underwrote or facilitated. So with all of this in mind, what can this account of the Roberts Court's embrace of Funhouse Footnote 4 tell us about the court and its jurisprudence going forward? At one level, this account of the Roberts Court and Footnote 4 provides a coherent frame through which to understand the court's approach to precedent, one that perhaps allows us to better anticipate the court's responses to particular claims. But perhaps the most important insight we can glean from viewing the court and its work through this lens is what it means for the logic of constitutional law and the constitutional order going forward. Under the Caroline Products framework, the Equal Protection Clause provided redress for harms against discrete and insular minorities. And for years, racial minorities, and African Americans in particular, were understood as the exemplar of minority status due to their history of discrimination, political powerlessness, and the immutability of race. But as I argue, the Roberts Court's distorted vision of Footnote 4 upends traditional notions of minority status. In the Court's imagining, there are new minorities who have been displaced in a new cultural landscape that is increasingly secularized and pluralistic. And critically, it is a cultural landscape that the Court, through its earlier decisions on desegregation, abortion, LGBTQ+ rights, and civil rights, has brought into being and cultivated. In this new cultural landscape, the laws and policies are now dictated by a new majority. And who is this new majority? Well, according to the Court, it is apparently comprised of women, sexual minorities, racial minorities, and other formerly subjugated groups who now have coalesced and collectively wield outsized power and influence to make demands in public policy and of the Court. The essential woke mob, if you will. The members of this new majority have rejected traditional mores for themselves, and more troublingly, with an assist from earlier courts, they have cemented their preferences as constitutional law and in public policy. And in doing so, they have displaced the old majority and consigned it to minority status. The question going forward is, will this vision of Footnote 4 continue to hold sway? I think it is very likely going forward that that is in fact the case. And what we will see in our constitutional order as it does unfold is crucially important. But the underlying question, the one that occupied Justice Stone when writing Caroline Products, and that should occupy us all today, is this the appropriate role for the Court? What is the Court's role in a constitutional democracy? Is it to pursue interventions in favor of discrete and insular minorities? In that case, who decides what is a discrete and insular minority? Who is among those who are most put out in society? These are the questions I think will occupy us and certainly will occupy the Court, but more importantly, should occupy those of us outside of the Court. Because much of the Court's own work in divining this concept of discrete and insular minorities was driven by work from outside, from individuals on the streets, in classrooms, outside of the Court, who agitated, people during the New Deal who insisted that, in fact, there was a role for the Court to play in upholding certain legislation. And maybe today there's a role for this new imagined majority to play in reasserting a more correct and refracted vision of Footnote 4. Thank you.
Thank you, Professor Murray. Before we end, I have two more honors left. And my first honor is to introduce Jerome Stone from the Black faculty and staff.
Is going to give it to you. So everyone, my name is Aaliyah Ranjit Singh. I'm an assistant professor in the Africana Studies program and the Caribbean Studies, the Africana Studies Department and the Caribbean Studies program. I'm also on the Wolf Board 2024 to 2025. I'm also the vice chair for faculty for Black faculty and staff. I'm going to pass it on to our secretary.
Hello, everyone. My name is Jerome Stone. I am the office manager of the Women's Center, as well as the Brooklyn College Anna PC project, as well as the secretary of the Black Faculty and Staff Association here on campus. It is a great pleasure and honor to present to you, Ms. Murray, with a small token of gratitude on behalf of the association for your work and your time that you have shared with the college. Melissa, you are the epitome of little but tolerant. No. It's a Jamaican proverb, meaning we may be small, but we are strong, determined, and not to be underestimated. So, to the great Melissa E. Murray, thank you.
And I have one more honor. I like to do surprises for you. I'd like to call forward the leadership of the Brooklyn College Pre-Law Society, Diana Reyes, Ari Tirado, and Michael Friedman.
I think we feel a little bit more comfortable doing our speech over here. We have something quickly prepared.
Okay.
If that's okay.
Yeah.
This is the only time we'll get this opportunity, by the way. No, I'm just kidding. So hello, good afternoon, everyone. My name is Diana Reyes, and I'm the current president of the BC Pre-Law Society. Welcome. This semester, I had the pleasure of reestablishing the Pre-Law Society with Ari Tirado, vice president right here. With the support of Michael, our treasurer, and Danish, our secretary, we have carried out events throughout the semester with the goal and mission of learning how to advocate for ourselves before advocating for others. And we've seen that in the form of networking, attending networking events, connecting with law school admissions counselors, and certainly visiting law schools. I was one of the 12 students who had the pleasure and honor of sitting in Professor Murray's class. Thank you not only for the invitation, but for being an inspiration for many students, including myself, and for opening spaces that not many students have access to. So thank you so much. Going back to our mission as a club, of becoming advocates for our own advocates, it is important for us to be in spaces like this one and engaging in conversations like the ones we've had throughout the week, especially during these times of uncertainty, where many folks of our community are being targeted, including students, immigrants, and undocumented folks, members of the LGBTQ community, women, individuals exercising their First Amendment rights from freedom of speech, religion, etc., amongst many more communities. Certainly, knowledge is power, and it is a significant form of resistance. So thank you so much. Therefore, we are thankful for your insights, knowledge, and wisdom you have shared with us throughout this week, and everything else you have shared, and for all the panelists as well. And now I'll pass it on over to Ari over here.
Hi guys. I don't know if I could compare that speech. I wanted to say again, thank you, Diana, for your speech and for your leadership. You've definitely shown that during the semester. Professor Murray, thank you very much for being here and having your presence. It's really important to us as students. My name is Ari Tirado, and over the semester I've had the privilege to call myself the Vice President of the Brooklyn College Pre-Law Society. And given the current political and social climate, the e-board and myself feel it necessary to take a stance. As our institutions are being placed on trial by the student body, and the examinations are taking place, there rings a bell at the top of this library. That bell is a call to the students, to the individuals who harbor knowledge, truth, and justice. It is now that we, the Brooklyn College Pre-Law Society, must jump on that call to action. But our call to action is not one of physical resistance. No, it is where our protest, no, sorry guys. It is not one of physical resistance, where our protests will take to the streets and march to the doors of administration. No, our resistance lies in our presence within the unfamiliar space that is law. A space that remains to be unrepresentative of the people outside these gates. The purpose of the Brooklyn College Pre-Law Society is to highlight the diverse body of pre-law students. As previously mentioned, we've had the privilege to roam the halls of law schools, but I continue to ask myself the same question. Do I belong here? And to that I say, of course I do. And the Brooklyn College Pre-Law Society is a space meant to bring in these questions, to remind students that they belong in these halls, and that it takes a community to break the barriers of entry into the field of law. Through your extensive career and accomplishments, Professor Murray, you are a trailblazer in the efforts to challenge the traditional narrative. Oh my gosh, that verse is good. Yeah. To challenge the traditional narratives of law. Your insights and presence has been proof of the meaningful change that we aspire to achieve as a club. Thank you, and I will pass it to Michael Friedman.
Thank you guys for coming. Thank you, Professor Murray, and it is our honor and pleasure to give you this gift on behalf of the Brooklyn College Pre-Law Society.
And this is why I love my college. And with that, if I could ask you all to please stand up and give our Hess Scholar a loving, long applause. And we're not done. We do have one more event, more public event today at 2:15 in the William Jefferson Room. We'll be having the co-host of Strict Scrutiny, joined by other podcasters to talk about podcasting in the current moment. And then tomorrow, Professor Murray is going to spend the whole day with students. So thank you so much for being here. Thank you, Professor Murray.